Applicable law in divorce. The Rome III Regulation. 1. Background. A proposal for a regulation dealing with applicable law in divorce was launched in July 2006 by the European Commission. Negotiations proceeded on this proposal until it became clear in 2008 that there were insurmountable difficulties in securing the necessary unanimity for adoption by the member states. Shortly thereafter, a group of member states resumed the initiative under the new arrangements for enhanced cooperation in the Treaty for the functioning of the European Union, and this led to the adoption of the Rome III Regulation on this subject. 2. Territorial and material scope. On from June 21, 2012, 14 member states became bound by the uniform rules on applicable law as regards divorce and legal separation. These were the original 15 states which applied to cooperate in this enhanced procedure, minus Greece, which withdrew from the negotiations and then subsequently gave notice of its intention to be bound by the regulation. Lithuania is also now bound by the regulation. The regulation excludes from material scope a number of matters of family law, similar to those excluded from the scope of the Brussels IIa regulation, many of which are now dealt with separately in other regulations. The regulation is of universal character, meaning that the law designated by this regulation shall apply whether or not it is the law of a member state participating in the regulation. 3. Choice of law. In terms of the regulation, the parties are permitted to make a choice between any of the following laws: the law of the state of the habitual residence of the spouses at the time the agreement to designate the law applicable is concluded, the law of the state of their last habitual residence if one of the spouses is still residing there at the time the agreement to designate the law applicable is concluded, the law of the state of the nationality of either of the spouses at the time the agreement to designate the law applicable is concluded, or the law of the forum. An agreement designating the applicable law may be concluded and modified at any time, but at the latest at the time the court is ceased. Also, if the law of the forum so provides, the spouses may also designate the law applicable during the course of proceedings. If they do, the designation so made shall be recorded in court in accordance with the law of the forum. The material validity of a choice of law is to be determined under the law which, in terms of the choice made, would be applicable were the agreement to be valid. The agreement on the choice of law has to be expressed in writing, dated, and signed by both spouses. Other additional formal requirements for this type of agreement may apply depending on the law of the member state of habitual residence of the spouses. 4. Applicable law in the absence of a choice. Where no choice of law has been made, the following rules shall apply to determine the law applicable: the law of the state, where the spouses are habitually resident at the time the court is ceased, or, failing which, where the spouses were last habitually resident, provided that the period of residence did not end more than 1 year before the court was ceased, insofar as one of the spouses still resides in that state at the time the court is ceased, or failing that of which both spouses are nationals at the time the court is ceased, or failing that where the court is ceased. 5. Other rules. Law of the forum applied. Where the law applicable pursuant to the regulation makes no provision for divorce or does not grant equal access to divorce or legal separation because of the sex of one of the spouses, the law of the forum shall apply. Exclusion of renvoi. The application of the law of a state refers to the rules of law in force in that state other than its rules of private international law. Public policy. A court may refuse to apply a provision of the law designated in accordance with the provisions of the regulation only if such application is manifestly incompatible with public policy of that forum. Differences in national law. The regulation does not oblige the courts of a member state whose law does not provide for divorce or does not deem a marriage to be valid for the purposes of divorce proceedings to pronounce a divorce by virtue of the application of the rules in the regulation.